So 30 senators just joined together to demand that the ATF rescind all of the Biden administration's rules that they put in place, including the pistol brace ban, the ghost gun rules, and a ton of other things as well. And this is in direct response to the Trump executive order. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company if you need supplements, protein powder, protein sticks, all of those things, but they're also pro-freedom, pro-America, and they support the Second Amendment. Check them out using the link down below. And if you order using my unique link and you order something $50 or more, you will get a free 4-pack of energy drinks. Now, like I mentioned in the intro, in this video, I have some very important developments in the fight against the ATF and all of the unconstitutional rules that they put in place, like the pistol brace rule, the 80%er restrictions, and all the other things that we've covered on the channel during the Biden administration. Now, in response to the executive order that was issued by Trump, which was to protect the Second Amendment, 30 senators have now joined together to send a letter directly to the ATF. And in this letter, they demand that the ATF cooperate with the Attorney General through that executive order and essentially eliminate all of the rules that they engaged in during the Biden administration, and also change a lot of the things that they have been doing which violate our Second Amendment rights. So the letter we're going to be talking about states that, Dear Deputy Director Richardson, thank you for your service in the ATF during the presidential transition. On Friday, February 7th, 2025, President Trump took decisive action to reaffirm law-abiding Americans' Second Amendment rights in issuing his executive order protecting Second Amendment rights. We urge you to immediately align ATF's rules and policies with the president's strong support for the Second Amendment. Under former President Joe Biden, ATF adopted numerous policies and rules that infringed upon Americans' Second Amendment protections. President Trump's executive order directs Attorney General Pam Bondi to review and develop a plan of action regarding President Biden's unlawful firearms regulations. We ask that you work with the Attorney General to quickly identify and rescind these policies. In particular, we call your attention to the following anti-Second Amendment regulations and policies which must be immediately rescinded. First, the engaged in business rule, which is an unconstitutional attempt to move the ATF to do all it can to impose universal background checks on law-abiding Americans. ATF has been enjoined, at least temporarily, from enforcing the rule because it violated the text of the GCA. Second, the pistol brace rule, which improperly reclassifies pistols equipped with stabilizing braces as short-barreled rifles, thereby subjecting them to stringent regulations and serious criminal penalties under the NFA and GCA. We are troubled by the fact that the ATF promulgated this rule after it previously determined that attaching a stabilizing brace to a pistol did not render the pistol an SBR. This rule threatens to put stabilizing braces out of reach of millions of gun owners, including disabled combat veterans who rely on them to be able to shoot heavy pistols. Furthermore, the rule made law-abiding Americans felons overnight by having lawfully purchased stabilizing braces equipped pistols. Multiple courts have already found that this rule to be arbitrary and capricious under the Administrative Procedures Act, and it was ordered vacated by the United States District Court in the Northern District of Texas. We appreciate the government's recent motions to hold the ATF's 5th and 11th Circuit appeals, defending the rule in abeyance and to postpone oral arguments, and the ATF should work quickly to uphold the vacatur given the ongoing litigation. Third, the so-called ghost gun rule, which cracks down on law-abiding hobbyists who are exercising their Second Amendment rights to privately build firearms, a long-standing tradition that traces back to the colonial era. The regulations are currently before the Supreme Court, but the ATF should act immediately to rescind this rule. Fourth, the zero-tolerance policy under which the ATF has revoked the licenses of federal firearms licensees over minor bookkeeping violations. This policy violates a decade-long precedent of the ATF, working with the FFLs to address these minor, unintentional violations and revoking the FFL licenses only in cases of major, willful violations that threaten public safety. The ATF should develop a program to restore the federal firearms licenses of those FFLs whose licenses were unfairly revoked or surrendered under duress, where they did not engage in willful conduct as understood prior to June 23, 2021, when the policy was announced. In addition to promptly rescinding these rules and policies, we urge you to immediately destroy the hundreds of millions of the ATF Form 4473 firearms transaction records and other licensee records that are over 20 years old. These records have no particular law enforcement value, but do contain the sensitive information of millions of law-abiding gun owners. ATF should likewise return to the policy of allowing FFLs to destroy Form 4473s in their possession that are over 20 years old, which the Biden administration initiated in violation of the federal prohibition on gun registration. Ending the policy of retaining these very old records will save money for the American taxpayer and counteract the ATF's unconstitutional rule change. Furthermore, we urge you to continue collaboration to improve the process of the National Firearms Act applications. Congress recently instructed the ATF to make these improvements. While the NFA wait times have improved significantly, the ATF must continue to address ongoing delays in application processing times until the archaic process is at least as efficient as the National Instant Criminal Background Check system. There is no reason that the right to purchase a firearm should be so greatly delayed. A right delayed is a right denied. The foregoing should not be considered a full accounting of every action or policy for which the ATF may be held responsible under the President Trump executive order, but represent obvious and high priority places for the ATF to initiate compliance. We look forward to working with you through the transition as you implement President Trump's agenda and reorient the ATF towards protecting American Second Amendment rights. So that was the letter that was sent by 30 senators, and all 30 senators are here on the screen. So if you want to see if your senator's on here and join this letter, this is the signers of this letter. This letter is attempting to assist in the deployment of the Trump executive order. Now keep in mind, some of these ATF rules, as acknowledged in this letter, are currently being litigated in various circuit courts of appeals. And in fact, the Vanderstock 80%er case is currently waiting for Supreme Court decision. The Supreme Court has already heard oral arguments on that 80%er case, the Vanderstock case, and they should rule on it before the end of their term this year. Now, also, multiple pistol brace cases are pending, and there's arguments pending in the Fifth Circuit and others. Ideally, in my opinion, I would like to see those cases be resolved in a pro-2A manner so that we have strong precedent in various circuit courts and even in the Supreme Court going forward against these types of actions of the ATF. In my opinion, just outright rescinding these rules will likely result in all these cases being mooted, and you wouldn't really have a ton of strong precedent, on the final resolution of some of these cases, especially if the Supreme Court then decided to moot the Vanderstock case. You wouldn't get a decision from them. Same thing with the Fifth Circuit on the final merits vacature of the rule. So just outright rescinding them without anything further could potentially, just moot those cases. And my concern with that going forward, of course, would be what happens when a new administration takes power. So if the Trump administration moves to just rescind these rules, I would like to also see at the very least legal statements being made by the ATF identifying that braced pistols are not SBRs under the NFA, that 80%ers are not firearms, that the engaged in business policy is incorrect, along with all the other things that they're doing and were asked for in this letter. I would like to see firm statements from the ATF correcting those, so potentially you could have, a way to stop any future ATF administration from doing the same thing. The point that I'm making here is that although outright rescinding these rules and deleting the registry would be a win, I would like to ensure that we don't, kind of waste this opportunity and also ensure that we get a long-term win going forward. But generally, this is good news that there is more pressure being put on the ATF and also the Attorney General to move towards getting rid of all these unconstitutional rules that were put in place by Biden and his ATF. So that's what's currently going on in this effort to destroy the ATF Second Amendment infringements that took place during the Biden administration and, the attempts to now walk back and get rid of all those unconstitutional rules. So as we get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you all for watching. Don't forget to like, comment, subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.